today's program will focus more on the contract for sale of goods, particularly the aspects which are relevant in the context of selling and buying goods. Now, we enter into agreements day after day. For example, taking a seat in a bus, dropping a coin into the slot of a box of a weighing machine, or going to a restaurant and taking snacks there, all are instances of contracts, but seldom do we realize that we are entering into certain amount of a contract with the seller or a buyer in that particular instance. Now, in the case of people, particularly the people who are engaged in commerce, industry and trade, which all collectively means business, they have to necessarily carry on their business by means of entering into contracts, and they have no escape from entering into a contract at all, because tomorrow if there is something goes wrong with the contract, they may have to actually take the help of certain legal provisions which are actually there under the relevant acts. Now, but then the question arises, what is a contract? Now, contract in simple words is agreement backed up by legal enforceability. That means, if the agreement is not enforceable in a court of law, it is not a contract, it remains to be an agreement only. For example, the social agreements are not enforceable in a court of law, that means they are not contracts. Now, it may be said all contracts are agreements, but not all agreements are contracts, because certain of the agreements may not be enforceable at law. Now, the question arises, which is really pertinent to today's chosen topic, which is contract for sale of goods. What is actually a contract for sale of goods? Now, when a student buys books from a stationery shop or a bookseller, or a housewife buys several cans of edible oil from a shop, or a coal mining company sells coal to a public utility company, or an airline company buys an aeroplane from a manufacturer, all these people knowingly or unknowingly are entering into certain agreements. Now, these agreements are actually the ones which come under the provisions of contract for sale of goods, which are covered by, which are governed rather by Sale of Goods Act 1930. And to tell you the origin of this particular thing, the provisions governing the sale and purchase of all these items, particularly the movable items, were originally contained in chapter 7 of the Indian Contract Act 1872. Now, in this background, what we propose to do is we will be discussing the different aspects relating to contract for sale of goods, which involve several aspects like what exactly is the subject matter of contract for sale of goods, and what are the essential elements of contract of sale, what is the difference between contract of sale, particularly the sale and the agreement to sell, and agreement to sell and hire purchase agreements, and what are the different conditions and warranties that govern the sale of goods, particularly the movable goods in this particular context, and are there any doctrines which are really relevant in this particular context, something like what is the doctrine of caveat emptor and so on. Now, may I now request Dr. Zaidi to describe the origin of Sale of Goods Act and what exactly constitutes a contract of sale, and the background which we have had so far.
Hello,
Dr. G.B. Reddy.
Well, as far as the Sale of Goods Act 1930 is concerned, it is a special contract which was enacted only in the year 1930, and prior to 1930 the law relating to sale of goods was contained in the Indian Contract Act of 1872, chapter 7 and sections 77 to 123. And in fact, this Indian Contract Act 1872 itself was based on the common law of England and the law merchant prevalent in England, but the sale of goods legislation was not codified in England till 1893. So, when the sale of goods legislation itself was codified in the year 1893, it was felt that in order to in fact meet the changing times and circumstances, especially the developments in the commercial world, a special committee was appointed in the year 1929, and on the recommendations of this particular committee, the Sale of Goods Act 1930 was enacted. And in fact, the main purpose of this legislation is to bring some sort of uniformity with regard to the contract of sale of goods, and not only in India, even in United States of America, we have a legislation called the Uniform Sales Act, and the provisions of this American legislation, Indian legislation, or most of the Asian and African legislations are on the same lines as the English Sale of Goods Act 1893. So, this is the brief
And
history.
probably if I could add, the very purpose of any law is to bring about uniformity in relation to transactions that are actually to be governed in a particular domain of law. That's a basic purpose.
Right.
Thank you so much. And how does, there are two things, like we enter into certain agreements to sell. Now, there are actually some agreements which are called contract for sale, for example, sale of goods. Now, what do you think is the basic difference between the agreement to sell and the contract for sale?
Sale. Okay. Now, in a contract of sale, there are two terms, like there is sale as well as agreement
to sell. What is the basic difference between these two?
That is, in a contract of sale, the property in the goods is transferred to the buyer immediately for a price, whereas in a contract for an agreement to sell, the property in the goods is to be transferred at a later date subsequent to certain conditions which are to be fulfilled. Now, after the lapse of time, or if the conditions do get fulfilled, then the contract for an agreement to sell becomes a sale. And apart from that also, there are certain differences between a contract of sale and contract for an agreement to sell. Basically, contract of sale is an executed contract,
Right.
an agreement to sell is an executory contract. And the type of goods also, in the case of a contract of sale, the type of goods is mostly specific goods. And in the case for an agreement to sell, the type of goods would be contingent or future goods.
Fine.
And then even if there is a risk of loss, in the case of a contract of sale, the loss has to be borne by the buyer, even if the goods are in the possession of the seller. And in the case of an agreement to sell, if there is a loss, the loss has to be borne by the seller, even if the goods are in the possession of the buyer.
Okay.
Then in the case of a breach of contract, suppose there is a breach of contract by the buyer, that is, the buyer fails to pay the price for the goods, or suppose there is a breach of some condition, then the seller can sue the buyer for the price, whereas in the case of agreement to sell, he can sue only for damages.
For damages. Right.
Yes, these are some of the differences between a contract of sale and contract for an agreement to sell.
Yeah, would you like to throw some light on the essentials of a valid contract for sale?
Yes, basically.
Now, as we have some essential elements of a valid contract.
Yes.
I am sure. So, also we should have some essentials of a valid contract for sale.
Basically, all the general principles of the law of contracts will apply to the sale of goods as well. However, there are certain essentials, there are certain elements, like one, we have two parties. There must be two parties in order to have a contract of sale. That is, one is the buyer, the other is the seller.
Okay.
And the subject matter of a contract of sale is goods.
Goods.
Movable goods.
Movable goods.
Yes.
Fine.
Now, if it is immovable goods, it is not regulated by the Sale of Goods Act. It is regulated by the Transfer of Property Act.
Fine.
And then the consideration for the Sale of Goods Act is, or rather for the contract of sale, is price.
Price.
As I said earlier, it could be in terms of money or barter. There is nothing to prevent it from being partly in money and partly by way of barter. Another essential is that the property in the goods should pass from the seller to the buyer in the case of a contract of sale.
Okay. We could know some differences between sale and agreement to sell. But the question is, in case of a sale and an agreement to sell, what do you think is the position of seller and the buyer when they become insolvent?
Well,
if they are okay, there is no problem. But if they become insolvent, there does arise a problem. What are the problems like?
That's right. In fact, as Dr. Rajeshri has already pointed out, in order to enter into a valid contract, one must have not been disqualified, and one of those grounds is insolvency. That is where the liabilities of a particular person exceed the assets, and when he is adjudicated as insolvent. The question is the time of insolvency.
The question here is, he must have been adjudicated insolvent.
As insolvent by a
not
competent
just the question
court.
of filing petition for some favor like.
That's right.
Okay.
The
that
payment
becomes
is,
more important.
That's right.
Right.
Then if the seller becomes insolvent after the sale, probably it will not have any impact. But if a buyer becomes insolvent after the sale, but before the payment of the money, then if the goods are already not in fact delivered, then in such a case the seller can always execute or get the transit of goods stopped. That is one. Second aspect is, if he is an unpaid seller where the amount is yet to be paid, the price is yet to be paid, in such a case the seller will have the lien, that is right to retain the possession of those goods till the amount is paid by the buyer or it is tendered. Then another very important aspect is, if the seller becomes in fact insolvent after the execution of the agreement of sale or after the sale, but before receipt of the money, then in such a case the sale price would be vested in the official receiver who is appointed by the court.
Okay.
So, this is
Now, how does actually a sale differ from a hire purchase agreement? People are talking too much about these hire purchase things, leasing and things like that. Let us not get into leasing area.
Yeah.
Let us confine ourselves only to hire purchase thing. How do you think a sale differs from hire purchase agreement?
Now, as I already said, in a sale, the property in the goods is transferred immediately.
Right.
Whereas in the case of a hire purchase, there is a contract between the owner of the goods and the hire purchaser or hirer.
Okay.
Now, they agree that the property in the goods, that is ownership, shall pass to the hire purchaser from the owner after a certain number of installments have been paid. Only after the last installment has been paid, then the ownership is transferred from the owner to the hire purchaser.
Okay.
And in this case, the hire purchaser is at a liberty to repudiate the contract or cancel the contract at any time. That is, he need not pay the balance of installments and say he does not want to be bound by the contract.
Fine. Do you think there is any difference basically between barter, exchange and sale, or are they the same?
No, they are not the same. See, barter is where goods are exchanged for goods. Say I give a horse in exchange for 2 bags of wheat.
Fine.
That would be barter. And exchange is where money is exchanged again for money.
Something like currency being exchanged for another currency.
Yes, I give
Okay.
$1 and you give me rupees.
Okay.
Then in the case of a sale, obviously goods are exchanged for money.
Okay. Now, we have been discussing something about sale of goods, and we already agreed upon the fact that the subject matter of sale of goods is, contract of sale is goods basically.
Yes.
You are okay. And what are the different types of goods that are actually considered under this particular sale?
Now, basically,
or all the goods considered, or they can be divided into certain categories or classified into certain classes, groups, for
Okay.
example. What I am trying to ask you is, what are the different types of goods?
goods. Okay. Now, basically, the most important thing is that goods has to be defined. Now, goods has been defined by section 2, subsection 7 of the Sale of Goods Act.
Okay.
Now, under this act, goods means every kind of movable property other than actionable claims and money, which means it could include stocks, shares, patents, trademarks, electricity, gas, water, etc.
Okay.
Now, there has been a classification of goods. Now, goods can be classified into existing goods, future goods and contingent goods.
Fine.
Now, again there is a sub-classification here. In the existing goods, you have specific goods, ascertained goods and unascertained goods. Now, specific goods are those goods which are identified and agreed upon at the time of contract of sale.
Fine. Could you give me an example?
Okay, I'll give you an example. Say I go to a TV showroom and in my mind I've already decided that I would want to buy a BPL, a particular brand, say BPL. Now, I go and test a BPL TV. Now, that would become an ascertained good, but I would want a BPL TV with some special features in it. So, once I get a TV with the kind of features I want to have and then decide and say this is the TV I want to buy, then that becomes a specific good.
Fine.
Now, all the other TVs in the showroom will be unascertained goods.
Understood. Fine.
Then you have future goods. Now, future goods are those goods which are not in the possession of the seller at the time of contract of sale. They either have to be manufactured or acquired or procured from elsewhere. Now, I would want to make a note here, that is, a contract of sale of future goods can also be a contract
Say
for an
example,
agreement to sell.
Say for example, you enter into an agreement with Dr. Reddy,
Yes,
saying that I will be able to sell this ring
yes,
provided I am able to acquire it from Sudhakar.
correct, exactly.
Now, I think that's
So that becomes, yes, that
okay.
becomes an agreement to sell.
right.
Then you have another category, contingent goods. Now, the procurement of these goods depend upon a contingency or an
Happening
event
or
an
not
event
happening
which
of a
may
particular-
or may not happen.
Right.
That is contingent goods.
Okay. Now, if the goods are destroyed, what do you think is the effect of this particular thing on say the position of or effect of on contract of sale if the goods are destroyed? Because
Yes.
the whole thing is about goods and those being transferred in terms of possession and all the things
Okay.
under a particular agreement.
Okay.
Assume that the goods which are subject matter of sale are destroyed.
Okay.
What do you think is the position of these things on or impact of this on the contract of sale?
Now, at the time a contract of sale is entered into, unaware to both the parties,
Okay.
suppose the goods are destroyed, and here when I say goods, I mean specific goods.
Okay.
If those goods are destroyed and it is not due to the fault of either of the parties, that is the buyer or the seller, then the contract becomes void. Same is the case when there is a contract for an indivisible lot of goods. Suppose a part of the goods is destroyed, yes, then the entire contract becomes void. Or if the goods are stolen, or if it has been seized by the government, so then the entire contract becomes void. Same is the case in the case of an agreement to sell also. But if the subject matter of the contract of sale or an agreement to sell is unascertained goods, then the seller is always under an obligation to fulfill his promise.
So, the effect of destruction of goods on the contract for sale depends on the basic nature of goods,
Yes,
right?
correct.
And
Specific
those
goods.
things are to be taken into consideration
Yes.
before actually trying to understand the impact of this on the contract
Yes,
of sale.
precisely.
Fine. You know, what are the different kinds of representations or statements that are actually to be taken into consideration before entering into a contract of sale? Now, these statements or representations go in the name of either conditions or warranties. That is what we understand. Now, what do you think are the different statements or conditions or representations that should be taken into consideration? Dr. Reddy, I would like to know from you.
Okay, well, in fact, before a sale is entered into or executed, there are certain representations or statements made by the seller to the buyer, and they may be with regard to the quality, quantity, nature or other like factors. If those terms and stipulations are essential to the contract of sale, then they are called conditions. For instance, suppose that A wants to purchase a car for transport or touring purpose, and when he seeks a clarification from the seller, and he suggests a particular car like a Bugatti car or some other car, and later on it was found that the car is totally unfit for transportation purpose or touring purpose, then the essential condition itself is defeated. So, that is the essential nature of the representation or statement made by the seller to the buyer. Then on the other hand, there may be certain terms and stipulations which may not be as essential or as important as the conditions. Probably we can call them collateral stipulations to the conditions. We call them warranties. For instance, nowadays the motor vehicle manufacturers, they give advertisements saying that under standard test conditions, so and so vehicle will give mileage of 75 kilometers per hour. And if the vehicle is not able to give that much mileage, instead of 75 it gives only 70 or 65, in such a case it may be called a warranty. And the basic difference between the condition and warranty is that if a condition is breached or in fact it is not satisfied, then it will give rise to total repudiation of the contract of sale. Then if the warranty is not respected or in fact not adhered to, in such a case it will give rise to damages. So, the buyer can sue the seller for claiming the damages, but he can't repudiate the contract altogether.
So, the conditions go to form the very basis of a contract,
Yeah, absolutely. In
whereas the warranties probably go to only strengthen a particular kind of a contract.
yes,
They becomes collateral.
that's right.
Okay. I mean violation of any of the conditions can give rise to the buyer setting aside the contract, whereas the buyer can probably sue the seller for damages in a court of law. So, the, I mean warranties are less pungent in times of,
That's right.
less severe in terms of
That's
punishment,
right.
fine. Okay. Now, what are the express and implied conditions? Dr. Reddy has clarified as to what conditions are and what the warranties are.
Yes.
There are certain express conditions, there are certain others which go in the name of implied conditions, and what are those implied and express conditions, what are the warranties kind of things. Would you like to throw some light on them?
Yes. Now, express conditions and warranties are those which are expressly provided in the contract itself. However, we do have certain implied conditions. Now, implied conditions would be condition as to title, which means that in the case of a contract of sale, there is an implied condition that the seller has an authority to sell the goods, and in the case of an agreement to sell, that the seller will have an authority to sell the goods. Then we also have sale by description, which means that if the terms of the contract say that certain goods of certain description are to be sold, then only those goods will be taken by the buyer. That is, if the contract says that certain apples will be sold, the buyer will not be obliged to take oranges instead of apples. It has to go according to the description. Otherwise, the buyer can repudiate the contract or refuse the goods. Then you have condition as to quality or fitness, which says that there is no implied condition as to quality or fitness. Now, this is an exception to the rule or doctrine of caveat emptor.
Caveat emptor.
Yes,
right.
caveat
Let the
emptor.
buyer beware.
Yes, let the buyer beware. So, there is no condition as to quality or fitness. However, we have exceptions to this rule as well.
Okay.
That is, now where the buyer makes it known to the seller the exact purpose for which he needs the goods, and he relies on the judgment of the seller and the seller's skill, then it is the duty of the seller to deliver only those goods what the buyer needs. The buyer is not obliged to take any other goods.
Fine.
Now, suppose it does not, like suppose certain goods are of a particular patent name or a trade name, there is no condition as to merchantability. It may not even be fit for the buyer's purpose.
Right.
And if a particular product can be used for a number of purposes, then it is the duty of the buyer to inform the seller the exact purpose for which he needs the goods.
Yeah, Dr. Reddy was saying, if a buyer goes to a shop and asks for a car which is actually to be used
Yes.
for transportation purposes,
Yes, and Bugatti
and
is
is
a
actually
sports car.
forced into a contract where
Correct.
he is buying a sports
Yes.
car, for example.
So, he can sign the contract, he
Right.
can refuse the
Now,
contract.
there are certain warranties even which usually are expressed in terms of sale by description. You said something about
Yes.
it. Sale by sample, for example.
Yes, sale by
Now,
sample.
what
That
happens
is,
there?
now when the contract says that there is a sale by sample, there is an implied condition that the bulk should correspond with the sample, and the buyer should have reasonable opportunity to examine the sample, and that the sample should be of merchantable quality. Then you also have another condition, that is condition as to merchantability. That means when I buy certain goods from a seller who is dealing in the goods of a particular description, that means there is a condition that they are merchantable or that they are of a merchantable quality. A pen which does not write, a watch which does not show time, all these are said to be not merchantable.
I think the clock shows time.
Yes,
it's
exactly.
Working today. Okay, fine.
So,
Yeah.
apart from that, you have certain other conditions like condition as to wholesomeness, etc.
Fine.
Then you have implied warranties, that is warranty as to quiet possession, warranty as to freedom from encumbrances, warranty as to quality or fitness, warranty as to disclose the dangerous nature of goods, etc.
Fine.
Now, all these are express and implied warranties and conditions. They can be varied depending upon the terms of the agreement.
Now, there must be some point where the parties involved in the whole process have to perform the contract.
Right.
Now, there are certain stages which are sequential in nature in a limited way. Now, what do you think are the different stages involved in the performance of a contract of sale? Rajshri, I mean, what are the different rules kind of thing?
Now, there are 3 stages in the performance of a contract of sale, that is transfer of property of the goods, that is from the seller to the buyer. Then you have transfer of possession, and then you have passing of risk. Now, it is very important to know the exact time when the property in the goods is transferred from the seller to the buyer, because risk follows ownership, and if action has to be taken against any third party, the true owner has to be determined. Then in the case of insolvency by the seller or the buyer, whether the official receiver has to take or come into the picture or not, again will be determined by the point as to who is the true owner, and even if there has to be a suit for price, the true owner has to be identified. Now the next stage is like there are separate rules for specific goods, etc. But however, the next stage will be delivery, that is transfer of possession, which means delivery of goods. Now delivery of goods means that is voluntarily transferring the goods or transferring the possession of the goods from the seller to the buyer. Now delivery can be three types. We have actual delivery, we have symbolic delivery, we also have constructive delivery.
Would you mind giving some examples for each one of those three?
Now actual delivery is, say if I have to give few books to Mr. B, okay, so then I actually go and deliver it to him, so that is actual delivery. Now symbolic delivery is where the goods are bulky in nature and say they are stored in a warehouse. I hand over only the key of the warehouse. Now constructive delivery means where a third party is having possession of the goods of the seller and he intimidates to the buyer that he is holding the goods on his behalf. This is known as constructive delivery. Now there are many rules as to delivery of goods, like the mode of delivery, like which way you would want it to be, like actual or constructive or symbolic. Then that is a payment of the goods. Once delivery is made, how the payment has to be done.
Okay.
Now before I could proceed, I would want to make a point saying that basically in a performance of a contract of sale, there are two reciprocal promises, reciprocal and concurrent promises. That is, one by the seller to the buyer that he would deliver the goods, and one by the buyer to the seller that he would pay for the goods.
Yes.
Yes,
the second part is more important.
Yes, second part is more important.
Okay.
Apart from this, of course, there are many more rules as to delivery of goods. That is, like you have the time, place where the goods have to be delivered. The buyer has to apply for delivery of goods.
Right.
Buyer has to apply to the seller for the delivery of goods, and the costs of delivery. Who has to bear the costs? Normally, the seller bears the costs of delivery, but to procure the goods, the buyer bears the costs. And then sometimes the delivery of goods could be of a wrong quantity. That means something less which has been contracted, less than the amount contracted for, or more than the amount contracted for, or the goods which have been contracted for can be mixed with the other goods.
Fine.
So all these are like they can be treated in a very different manner.
Fine.
Like then for example, like suppose now I contract for say 500 bales of cotton. Yes. Now I get only 200 bales. Either I have the option to either reject the goods or accept the 200 bales of cotton and pay for it at the contract price.
Thank you so much, Dr. Reddy. I should also thank you, madam.